All right, Eric Douglas, Chris Vaughn here with Family Wealth Planning Partners. Welcome to another episode of the Retirement Planning Happy Hour here on another lovely, beautiful Friday morning here in Louisville, Kentucky.
When's the last time we saw the sun in Louisville, Kentucky?
No, it's not very sunny actually.
It feels like Oregon. It's like, oh my gosh.
Yeah, it's not too terribly nice outside right now, but that's okay because we can get through it with a pretty good bottle of bourbon here.
We have happy hour, right?
That I've never tried this one before, and so we'll go through that here in just a moment. But you had a specific topic that you wanted to bring to the table today.
I wanted to talk about estate planning today, and it's something that we've debated. Do we want to talk about it? Because it's not the most exciting topic. Let's just get that out in the open.
For sure, yes.
So we'll do our best with that. But I had something happen this week with a client of mine, or I was made aware of it, that kind of necessitated, did I say that right? Necessitated the need to talk about estate planning and the importance and stuff like that. So that's what we're going to get into today is proper estate planning, things that you need to do, how that fills into your financial plan overall, so on and so forth.
And what are we sipping on today while we talk about this very dry topic of estate planning?
Right? So if you're familiar, Jefferson's makes a fairly good bourbon, right? But they got famous a few years ago doing what they called Jefferson's Ocean. And you were saying, you're familiar with it.
Yep.
So the concept, it's very gimmicky, right? They take regular bourbon, and they put it in the bourbon barrels, but then they put it on a boat, right? And I don't know exactly how they do this, but I'm imagining that it's all palletized and put into big cargo containers. And then it's put on a ship and sailed around the world, and the idea is that the ship moving up and down causes the juice inside the barrel to slosh around. That's got gimmick written all over it to me, but if you get around, I don't need, each one is called a voyage, right? The joke in the bourbon community is that the Jefferson's Ocean is like Star Trek movies. The odd-numbered ones are really bad, and the even-numbered ones are really good, or maybe I'm saying that backwards. But a couple of years ago, this bottle popped up on my radar. The guy that owns a liquor store where I live, that if you know anything about getting the unicorns, that's how you do it. You always do your business with them. And,
you know a guy. Yep.
Right. I got a guy, right? Well, my guy pulled this out one time when I stopped by, and I'm immediately looking at this going, I do not want to buy that because I know it's a gimmick. But the deal is when they hold something for you, you got to buy it. Or the next time you want something really good, they're not necessarily going to hold it for you. So I bought it on a whim. So this is called Jefferson's Tropics. And the gimmick here is that they put it on a boat, they sail it to Singapore, which if you know anything about geography, Singapore is 85 miles north of the equator. It is brutally humid. It is hot year-round. My son and I are big F1 fans, and they go to Singapore every year, and it's a night race. And all of the mechanics, the drivers, are just standing there dripping because it's so miserably humid. And the idea was that if you leave it for, I think it's 18 months, in that brutal heat and humidity, that it will change the chemical composition. Never even opened it. Took it to a bourbon event one night with a lot of friends of mine that are real snobs. In fact, that's their name. And everybody said, Chris, have you tasted this one you brought yet? Nope. Wasn't planning on it either. It's really good. So that's what we're drinking today. This is Jefferson's Tropics. There are a couple different versions of it. This is the very first release that they did of it. So that's what we're going to drink while we talk about arguably the least exciting subject in financial planning.
Yeah, definitely does not make it the least important.
No,
however,
it's super important. That's what we're going to talk about. So.
And we all have, unfortunately, experience in this realm. It's a sad reality of what we do, obviously, as we work with clients that typically have money and who typically has the most money. You're typically talking about older folks, right? So, so it is a reality that we have to deal with, that we have clients pass away. I can't remember personally, I had four last year that passed away. I think you
so
just
the year before I lost 3 in a 4-month window. I mean, and across multiple age groups too.
And they come in waves, unfortunately, just like anything.
They do.
So So, knock on wood, we've been blessed this year so far. But you had a situation that you wanted to bring to the table and discuss that highlights the importance, the necessity, as you said earlier, the necessity for a quality estate plan.
Right. So, so here's the situation. I'm going to change the story just a little bit to protect the actual people. But what happened was my client, I was notified that there was a family issue going on. I didn't know what that was. Right. Mm-hmm. Okay, fine. They'll let me know when it's time. I found out just this week her adult daughter was killed. Right. Sad situation. The reason I found out is because she was given a transfer paperwork for the company where her daughter had her 401k. So that may sound very straightforward. We do not know how much money is in that 401k. It could be tiny. It could be huge. We don't know. What we do know is this. The letter was sent to the estate of, not to my client by name. It was sent to the estate of the deceased, and I immediately knew what's coming.
So what does that tell you immediately that they did not do?
Okay, two things. One, for sure, there was no beneficiary listed on the account.
Exactly.
Right?
Which is just
and
step number one.
Yes, and by the way, people will say, well, I have a will. Beneficiaries on accounts trump the will. That's true of your checking and savings account at the bank. That's true of your IRAs. That's true of your brokerage accounts. A beneficiary designation trumps whatever your will or your trust or any other legal document says. You got to know that up front. The fact that she did not have a beneficiary listed suggests she had no will, which means she passed away in a phrase we call intestate, right? So intestate, and I don't, if you've ever had to deal with these, they are a pain. When I read that letter, I went, uh-oh, my life is about to get difficult. And unfortunately, I'm going to have to tell people things they don't want to hear. Because you already have a sad situation. You've lost a child.
Well,
right?
just to clarify too, so this was the daughter of one of your clients. So the daughter was not necessarily your client.
Daughter was not my client.
Okay.
No.
So just to clarify that up front.
Which, once again, that comes back kind of tooting our own horn. Good financial planning includes going through the estate planning process and then making sure not only that it's done correctly, but that it stays up to date. And we've all had circumstances where something came up, and we'll talk about that a little bit later. So anyway, most likely she has passed away intestate, meaning no will. So everything's going to go into an estate. Now, here's where it gets complicated. She was legally single, but she did have a live-in boyfriend, right? Okay. Judge that as you will. But he had a daughter that was not hers, and she treated that child as her own child. But legally, she wasn't, right? So most likely, this is my suspicion, it would have been important to her. This is typical of parents and step-parents. They want their children to benefit from their money when they're gone, right? But with no beneficiary designation, with no will, with no nothing. And by the way, the parents, so my client and her former husband that actually had their daughter together, they're divorced, obviously. Both of them are remarried. There is little to no communication between them. So now you've got multiple marriages, multiple divorces. You've got living together relationships. You've got stepchildren, and you can see how this is going to get really complex really fast. And the problem with not having the estate plan done is when this is done, nobody's going to be happy. There is no good outcome here.
Well, I can tell you one person who's going to be happy.
And who is that?
the probate lawyer.
Yes,
that is
handling lawyer.
That is handling the case because they will be they will be getting paid from the estate, and nobody else will be happy about that for sure.
So anyway, when you talk about putting together a good estate plan, a lot of people will come into us and they'll say, I need to get a will. I need to get a trust. I need to do this. Okay, let's stop back or stop and look back a little bit and say, let's not determine what documents you need. Let's determine what you want to accomplish, right? Kind of that Stephen Covey concept. Tell me what the end result is, and then we'll work the plan backwards to where we actually are. So the way that we kind of teach this to clients at FWPP is there are 3 stages of estate planning, or phases, whatever you want to call them, 1, 2, and 3. So the first stage basically just gives direction to your money, right? And that requires a will. So when you pass away, if you have a will, then the will is going to dictate where anything that doesn't have a beneficiary designation on it, where that's going to go. You hear when you watch the movies, and I'm thinking the movie Knives Out pops into my head. If you haven't seen that movie, it's fantastic.
Yeah, good movie.
You hear about these wealthy families, and somebody dies, and they have a will reading.
I saw one like 2 weeks ago. I don't even remember what the movie was, but I remember just laughing because they brought someone in, and they were having this will reading, like you said. The mom had passed away, the matriarch, and all the kids were gathered around the living room, and some lawyer came in, and they were going through everything. It's like
there's only one place where that happens, and that's Hollywood.
Yeah,
nobody that has major assets has a will reading. Now, there's a lot of stories, and I challenge you, if you're watching or listening to this, look this up. Just Google famous people who have died intestate, right? Yeah. Like Abraham Lincoln. Okay, Abraham Lincoln was an attorney, but this was an attorney in a different time. I don't know that Abraham Lincoln was worth a lot of money or not. I don't know. But I know Michael Jackson was. No will, no nothing. That thing is still tied up in courts, as last I heard.
Well, James Brown.
James Brown, yes.
They couldn't even get him in the dirt.
Yeah.
Because there were arguments about that. I believe Prince.
Prince died intestate.
Aretha Franklin was another one. There's so many.
These are all people who, theoretically, there were some pretty serious assets because of how famous and successful they were. There's all kinds of legal messes that go along with that. So when we talk about how the will reading never happens, right? That's not what a will is designed to do. And I'm going to stress to you, remember that level 1 that I was just talking about? Level 1 gives direction. That's it. So when you die, this person gets this. This other person gets that, right? It's really basically all it does. Now, there is one major one. And if you are a parent of minor children and you do not have a will, you need to get this done today, right? Stop what you're doing and get this done. If you are a grandparent and your children do not have wills, wills are also going to establish guardianship. So when somebody passes away intestate and they have minor children, the court is going to decide who gets custody of those children. And if you've got a great family situation and everybody knows who the right person or persons are to have custody of that child, you can go to the court. Most likely the judge is going to say, yes, that's fine. Everybody agrees.
Or if wishes had been spoken about or discussed prior to, yes.
But that judge doesn't have to do that. The judge has the discretion in this case, and you could get tied up for years over custody battles. And you hear horror stories about it, right? If the will establishes guardianship, then that takes care of that from a legal point of view, right? So if you're a parent and you don't have a will today, that is a stop what you're doing and go get it thing, in my opinion. The other thing that I would do, and I've had this conversation with clients many times, if you want, so your brother and his wife, for example, you want them to be the guardians of your kids if something happened to you. Are they aware of that? It would kind of be nice to know, right? So, for example, I still have one minor child through the rest of this year. He turns 18 in December. But we established with my sister many, many years ago that if something happened to my wife and me, that our kids would go live with my sister. Everybody was in agreement. My sister was okay with that. But, and this is the second part of that, if your sister, parent, friend, whoever inherits your kids, what happens to them financially? I've got 2 boys. The sheer volume of food that they eat would break some people, right? So you have to look at it. So my sister, I'll use myself as an example. They had 2 girls, and they were a one-income family. My sister was a stay-at-home mom, and they were fine. But if they inherited 2 kids, and now all of a sudden they've got 4, especially with my kids' appetite, it would have put a serious financial strain on them. So I structured my estate plan so that not only would my kids be taken care of, but my sister and her husband would have the financial means to not be harmed by my death and my wife's death. So that's the first part of it. That's phase one, if you will. Mm-hmm. Phase two. So we'll move on. Phase two gives you direction, and it also gives you control, which to me is the most important one. I'm a bit of a control freak. And it also gives you probate avoidance. And that's where we get into what's called trust planning. I'm a huge fan. There are very few people that I talk to that I believe that a trust is not appropriate. Now, that's a decision for the estate attorney to make, but it's pretty clear in most cases. So what a trust does, and this is where we're going to go way down a rabbit hole, a trust is a legal entity. And that trust should then own basically all of your stuff, right? So when you pass away, the trust does not die. The trust is still very much in existence, and it still owns those assets. So the primary thing that you do with a trust is you allow it to own things, right? Okay, rabbit hole time. There are three different people.
Are we not down the rabbit? Are we not down the rabbit hole yet?
We're going to go down a separate rabbit hole. Okay, there's three people in a trust, right? There is the grantor or grantors. There is the trustee or trustees, and there is the beneficiary or beneficiaries. Okay, so the most common type of trust is what we call a revocable living trust. I've got one, you've got one. That's the way we do it. My wife and I are the grantors. We're the ones who put our assets into it.
The person who funds.
We funded it. Yes. That's the correct
who
word. Right?
Grants the money. Yeah,
right?
Yeah, absolutely.
We are also the trustees, meaning we have the decision-making ability about any assets inside of it.
You maintain control.
And we're the beneficiaries of it. So for all intents and purposes, it feels very normal until something happens to us, and that's when it gets important. Right?
Let me add one more thing,
please.
too, because a lot of times we get questions around, well, how does this affect my taxes? And a lot of people think mistakenly that doing a trust is some type of a tax play. And we'll go down that rabbit hole, right? When you start to get into estate tax avoidance and things like that. But for 95% of all trusts that are out there, you're basically doing basic revocable living trusts, right, as you just said. And the basic living revocable trusts pass through or flow through,
a pass through. That's right,
to the owner of the trust, right? So there's really no tax benefit, if you will, to owning a trust. That's not what a trust is designed to do.
That's not what its purpose is. And I'll use myself as an example again. My wife and I own nothing except for the trust. Right? Yeah, the furniture in our house, stuff like that. Our home and our property is owned by our trust. If you were to look me up on PVA, you will not find me, but you would find the name of my trust, right? Our cars are owned by our trust. Now, full disclosure, if you're going, hey, we've got a trust and our cars need to be in it, if you're making payments on your car, you can't put that in a trust. You can do that with your home or with real estate, but not with cars. So you have to pay them off first. My business. So I own, just like Eric does, I own a business. I'm the sole person involved with it, and that business owns 25% of our firm. Right?
Of our business, yep.
I don't own any of that. My trust owns all of it, and that's the point, right? I still have to pay the taxes on my house, I can assure you, right? I still have to do all of that stuff. It all flows through.
Yeah.
But if something were to happen to me and my wife, right? My son, my oldest, is 19. He's about to be 20. My youngest is about to be 18. If we didn't have a trust, and we've got them listed as beneficiaries on our IRAs and our other investments and the house and all that stuff, I'd like to think that I've done pretty good with my kids so far as far as money goes, but I would have no control whatsoever on what they do with it. They could blow everything that Kathy and I have spent a lifetime building in a weekend. I always have that flashback. If you remember Brewster's Millions, remember that movie?
No,
you're on. You got to go back. That's way back then.
You're going back to the 80s, right?
Yeah, like really early 80s. Yeah. But the whole point here is they could have an epic weekend. My oldest is a car junkie. I said, we were F1 fans. He could go out and buy a Ferrari, and there's nobody that can stop him.
We brought, so I brought a client on, this was 4 or 5 years ago. had a discussion, very early on as we were bringing them on, and we started talking about estate planning and, what have you done? What do you need to do, et cetera, et cetera. They had one son who had no clue how much money the parents were worth.
All right.
Not a clue. Okay.
Fairly common.
Yeah. And these were not people that lived an extravagant lifestyle. So you would have thought, very much the millionaire next door. Right. And we talk about that quite a bit. And that's going to be probably the bulk of our clients. So the son clearly had no idea how much money the parents were worth. The son had a job. He had just recently graduated from college. He wasn't making a lot of money. He was dating pretty seriously a girl that the parents didn't really like, and they didn't really like her intentions. So there was that in play, and you actually see that far more often than you probably would expect. So I kind of hit him with the questions. Well, if something were to happen to the two of you, how would you feel about your son, once again, only child, your only son, receiving all of the money that you're worth? And you could just see, in that moment, that was a question that they had never thought of. Their eyes got yay big, right? Their eyes just lit up and like, oh, we had not really thought about that. Yeah. And so they had him listed as the beneficiary, and they had kind of done the absolute basics, right? So it wasn't a situation where it was going to go into intestate. But there were no guardrails. Zero guardrails. And you could clearly see by their reaction when I asked them that question that they knew that their son was not prepared to inherit that level of wealth at the drop of a dime.
Wow.
So
great example.
Yeah.
I like to think, as I said, that my wife and I have done a good job raising our boys as far as teaching them financial responsibility, so on and so forth. But to use your word, there are no guardrails without that trust.
Yep.
They turn 18, they inherit. So if they're 10 years old when you pass away, right, and you've got, say, an IRA, and you leave that IRA to your 10-year-old, whoever is the guardian cannot use that money to help raise your child. They're not allowed to. And when that child turns 18, happy birthday. Boom.
So it goes into a custodial account, right? And then at 18, it's out of the custodial account.
Yep. Nobody, and I mean nobody, can tell them what they can and cannot do with that money. Oh, and by the way, in the case of an IRA, they'll go out and spend all the money because most 18-year-olds are total idiots with money. I was, right? Mm-hmm. And then find out, oh, by the way, you had to pay taxes on that money. So you can just see how this gets so dangerous.
That's an expensive lesson to learn.
It's a painful lesson, right? So in the case of a trust, the way that this would work, because the trust either already owns the assets, or in the case of what we call qualified accounts, so IRAs, 401ks, things of that nature, the trust is the beneficiary of them, right? So everything flows into the trust, either while you're alive or upon your death, through using proper beneficiaries. Everything flows into that trust. Now, I still have control. I'm playing golf with Jesus right now, but I still have control over how that money is dispersed or spent. And I'll give you some examples.
Is Jesus as good a golfer as the Lamb?
Probably.
Okay.
I'm going to go with yes. I've got some funny jokes about that one. But anyway, the money is only going to be dispersed in the way that we determine in the trust. Now, the trustee can be given some discretion, right? But they also cannot violate the rules. So in my trust, for example, and this is very standard language, if the beneficiaries, which is my two kids, if they have alcohol addictions, gambling addictions, drug addictions, anything like that within the past, I believe it's 3 years is the way we worded that, they cannot get a penny. Right? Because I don't want to fund an addiction. At the same time, money can be taken out.
Did you say gambling too?
Gambling, absolutely.
You can add gambling as well. There's all kinds of different provisions.
Yeah, and those three are fairly standard.
Yep.
But you can put anything that you want to in there, really. They can get money for education, but the money is not given to them. Right? The trustee would pay the tuition bill. Or, the trustee could say, okay, in order for you to get to school, which was an approved school by mom and dad, you have to have a vehicle to get there, right? Okay, but the trustee can use the discretion on how much money to spend on a vehicle, right? Those types of things. In my personal trust, right, this is a biblical concept, those who will not work shall not eat, right? There's a paragraph in my trust that says if the kids are refusing to work, they're capable, they're not disabled, that's different. They're capable of working and they're choosing not to, they get nothing. Yeah. I made them read that paragraph the last time we updated our trust. They are aware that I'm not joking on that. So those are the kinds of things you can do with a trust. That's where we say, level 2 is control. My wife and I are gone. I'm playing golf with Jesus, right? But I still have control over the way that my money that we work so hard for is being dispersed. Okay, so that's level 2. And the other thing, and this is, I don't know why so many people get obsessed with this part, it also avoids probate. Mm-hmm. Probate is not as big of a deal as what people make it out to be. It's a hassle. Right, it can have an expense to it.
It's hassle. It's time consuming.
Yeah.
It's a thing you shouldn't have to worry
about.
Right.
It does take care of that. If you fund the trust properly, there's really nothing to go into probate. But I would not tell you that you should go get a trust because you're trying to avoid probate. You get a trust because you want control. Mm-hmm. That's really what that comes down to.
So let me ask you this: what are your thoughts? Because you talked about qualified accounts.
All right.
And because we know that the rules changed through the Secure Act a couple of years ago, so the way that you inherit a qualified account is if you're a non-spouse, that is. A spousal, you obviously have the right to continue within a spousal IRA, any and all assets that are in an IRA. However, if you are a child or a non-spouse beneficiary, you have 10 years to completely distribute the entirety of the account. So it's interesting because I hear a lot of different opinions on this from estate attorneys.
Yep.
Okay, so there's no. It's funny because you would think
no right answer here.
Because you would think estate attorneys would all think the same, and it's funny. You talk to a financial advisor, you can ask 10 financial advisors the same question, and you might get 7 or 8 different answers, right? So same thing here applies in regards to qualified accounts. So what would your opinion be? Because you mentioned listing as the beneficiary on qualified accounts that have to be distributed within 10 years. Listing the trust as the beneficiary.
Okay, so
versus just listing the kids, for example.
Right. Okay. So first of all, that control thing comes back in. Mm-hmm. So if let's say I don't have a trust, right? My wife and I both pass away. Our IRAs, 401ks, so on and so forth, then get inherited by the kids. To your point, the rule is from our date of death, they got 10 years to get the money out. But there's no rule on the sequencing of that. They can do it all at once. They can wait till the very last day. They can really do anything they want, but there's no control, right? I'm a control freak. I admit it. Mm-hmm. By having the trust inherit what is now an inherited IRA, the trustee. So in theory, the trustee that you pick is somebody who is financially responsible and wise enough to handle it, or you can get what's called a corporate trustee, where you're actually hiring a professional or a firm to run it. So when you're dealing with somebody who is financially responsible or somebody who is legally responsible, like a law firm, for example, it's on them if they don't get that money out in the right thing. That's where they can be held accountable through the court system. So my opinion on that is, and once again, I work with multiple estate attorneys, as do you. They all have different opinions. The spouse should benefit or should be the beneficiary on any qualified account if you're married, because the spouse gets to keep that money as if they were the one who contributed it in the first place. The trust should be the contingent, because now the trustee can disperse those funds based upon what your wishes were.
Okay, so let me ask you this before we move on to level 3, and we probably don't need to spend too much time on level 3 because that's very, very,
it is a
very specific.
Yeah.
But you talked about corporate trustees.
Mm-hmm.
So in most cases, the trustee is usually going to be the owner, at least until they pass away.
Right, until they pass.
And usually once they pass away, the trustee or the beneficiary, the trustee is usually going to be like a child.
Right. An adult child.
An adult child, yeah. Some variation there of a brother or sister or something. So you mentioned using a corporate trustee. Mm-hmm. So what are the benefits to using a corporate trustee? Why would you go that route versus using an individual?
Okay, so once again, this is my opinion. A corporate trustee doesn't have to be as fancy as what the phrase sounds. It can be an individual that is not related to you, and they are going to be financially compensated
Yep.
for their work. So it could be an attorney, it could be a law firm, it could be a bank, it could be a financial planner in theory.
It could be a friend.
It could be a CPA. It could be anybody, but they're going to be compensated.
Power of attorney, trusted friend, trusted confidant. Some, thinking back to the mafia movies, the consiglieres, right? A trusted friend of the family, right?
Yeah.
It could be anybody, so it doesn't necessarily have to be a quote unquote trust company. Just someone who's in a level or a position of trust.
Right.
But I think immediately some situations that come to mind immediately as to why you would use a corporate trustee, whether it's an individual or a quote-unquote trust company. Mm-hmm. Let's say you have multiple children and you don't want to elect one.
Yeah, there you go.
And also you don't want to elect multiple children as co-trustees.
That's a hot mess, and I've seen that one.
So what's the old saying in football? If you've got two quarterbacks, you don't have one.
You don't have any.
same thing applies here. So if you have multiple trustees on a trust, they could disagree about if you do set up guardrails. They could disagree because the example that you used earlier in regards to your kids was if they're not working, they don't get paid. Or maybe they are working, but let's say they're working, I don't know, some temp job. Very, they're working.
Define working.
Exactly, right? And so you could have two trustees that are defining that differently. Or, okay, maybe one's going to define, 3 years sober differently than someone else, right?
Yeah, there you go.
So that's why it typically helps to have one trustee. Plus, it's also a bigger pain to have multiple trustees sign off on anything and everything that occurs within the trust. So that's one reason. Either if you have children that maybe have history of addiction or some levels of or lack of trust, I should say, or if you just have multiple children and you don't want to put it on just one person, because
or
that
you
could
multiple children that don't get along, and we see that a lot.
Well, they don't get along, or let's say they do get along.
Yeah, maybe too well.
Well, it's not even so much that, but maybe they do get along while you're still alive, but when you pass away, it's amazing, and we've seen it, and it's a cliche, but it's a cliche or a stereotype for a reason. How people become a little bit. They get along maybe a little bit less when money gets involved.
Yeah, money changes people, unfortunately.
And so you start talking about entitlement and things like that. So if you have kind of a neutral third party who is removed from the inner workings of the family, that's another reason why you might elect to choose a corporate trustee.
I was going there, and that you couldn't have said that better. Neutral, right? There's no emotion involved. They don't benefit from this. They get paid no matter what.
Yeah,
so they're going to do what the trust says as the way that it's defined, right? That's one of the real benefits to not only just a corporate trustee, but one that is unrelated, right? So, for example, a law firm. We have a mutual friend that's a CPA that serves as a trustee for several different trusts because he's an independent third party. He has no benefit one way or the other. He gets paid to do the job, right? Mm-hmm. And that's the real benefit of a corporate trustee. Now, the real con of a corporate trustee is, as opposed to, say, a trusted family member, you got to pay them, right? The trust has to pay them. And most trusts that I've seen, it's somewhat ambiguous how much they get paid. And guess who gets to make that decision? That trustee, right?
Yeah.
Now, before we move on, one thing I want to point out about corporate trustees that I think most people don't really know. So you go out, you create a trust, right? You say that, while I'm alive, I'm my own trustee, but upon my death, XYZ law firm is going to be our trustee. Okay, you can put that in the trust. That's the way you should do it. Your beneficiaries, so maybe your adult children, for example, your beneficiaries can fire that trustee. They have to go hire another one, right? But they can fire that trustee. So there is a safeguard, if you will, for the trustee paying themselves too much if you did not put that in there. If you did not put that language in there. They can fire them for any reason they want, but they can't do anything with the trust until they hire a new trustee. So keep in mind that the trustee can be changed by the beneficiaries. They just can't make themselves the beneficiaries when the trust calls for a corporate trustee. Now, we're way down the rabbit hole on that one. Okay, I think we've probably beaten level 2 to death.
We have.
So before we move on to level 3, which is going to make some people's heads actually explode. So if you're listening to this while you're driving down the road, you might want to pull over. Let's talk about bourbon for a minute. What do you think, since this is your first shot?
It's light. I don't know how best to describe that. It's light. When I say
this is 104 proof.
It's 104.
This is not low proof. It's not very high, but it's low.
But it's pretty smooth. It feels light. It doesn't feel very thick. Like there's no. Sometimes you feel like almost a coating.
Yeah.
There's none of that. It definitely doesn't taste like a 100 proof.
No, it doesn't. I'll tell you what I like about this. What I tasted it, and there are tasting notes. So there's a little tag that was on the bottle that said, you're going to taste vanilla, and you're going to taste... You know what I taste?
What's up?
Spicy apples. Now, there's a subliminal thing to that. By me saying that, it's entirely possible that you're going to go, wow, I taste spicy apples too.
Maybe, yeah.
But that's what I taste. And I mean, those really, really good cinnamon apples that have almost a bite to them, like there's a little bit of... cayenne pepper or something in there. That's what I taste in that. But it's not overpowering. It's a very, very pleasant bite to it. That's what I taste. I love this.
It's a smooth drinker. When you say aged in humidity, right? In Singapore, you wouldn't think of kind of a smooth, mellow.
I think about getting smacked inside of the head.
Yeah, but it's a very mellow taste.
Yeah.
It's light. Yeah. I don't know, like airy. I don't know how to better describe it.
It's got a surprising amount of flavor. I don't believe there is an age statement on this anywhere. I may be wrong. I'll look real quick. No, there's no age statement, which means if you don't know anything about bourbon, if there's no age statement on there, it could be pretty much anything. It has to be at least 2 years old, or you can't call it bourbon. And if I remember correctly, if I'm wrong, please post in the comments. To call it Kentucky straight bourbon whiskey, it has to be 4 years old, along with several other things that go in there. There's no age statement, so we don't know. I would guess this is not a very old bourbon. When something is old, they're going to want to put that number on there because that's a selling point. When you put a 12 or a 10 or, God forbid, a 15 or an 18 number on there, it jacks the price up.
What was the price
right?
price point on this?
When I bought this, and this was in the absolute height of the bourbon obsession here, probably 2 years ago, this was, I want to say it was $100. I'd be willing to bet you could get it for less than that now, but not by much because it's still kind of gimmicky, which is interesting. Just a little side note before we get back into our main topic. We were talking about this earlier this week. We had mentioned how the bourbon industry is kind of slowing down. The demand is slowing down. So the people who are not bourbon people, it's just the latest cool thing, they're kind of moving on. Maybe they're not drinking as much because we all know that the COVID lockdowns, the alcohol business exploded.
Well, they're moving on to other more...
They're moving on to other things.
The hot thing...
Tequila looks like it's the hot thing now.
Tequila's growing. You're also seeing THC stuff, CBD drinks, and so...
No thanks. I'm old school.
I'm just telling you what's kind of...
No, you're right.
What's becoming more popular.
As things kind of cool down, but all of these distilleries pump so much stuff out. And, of course, it takes years to age, right? You don't just go make bourbon and sell it tomorrow. It takes years. It's not like vodka is where you can sell it the next day. A lot of really cool stuff is becoming more and more available. So just this week, I stopped by a local big box store because I was driving past. I had a few minutes just to see if they had something. And we actually thought about having it on the show today. If you're familiar with 1792, which that's a Barton product, but if I'm not mistaken, 100% of it is now made at Buffalo Trace. They have several different incarnations of that. Their regular small batch is easy to find. It's very good. Their full proof is exceptional, by the way. And you see a lot of barrel picks of that. Well, now, every time you go to a liquor store, they've got a barrel pick of 1792 full proof. And it's common. It used to be extremely rare. But the really rare ones were what they call their aged 12 years. So it's a 12-year-old bourbon, which theoretically is the magical age for complexity. And they also have one called sweet wheat. I have never seen sweet wheat for under $100, ever. And you very rarely see it. And I've never seen the 12-year for under $200. And you never see that one. I walked into a big box right up the street from our office. They had the 12-year for $68. It was a limit one, but it was $68. That's retail. And they had the sweet wheat for $48. Yes, those did get added to my bar at that. That's a retail price.
As much time as you hear about real estate market crashing, well,
there
the
you go.
bourbon market crashing a little bit there.
Okay, there's pros and cons to that though.
Yeah.
Part of me, as a Kentucky guy, I want to see that industry really do well because it brings a lot of money into the Commonwealth. Yes, we're in a Commonwealth, not a state.
Yeah.
There's a great trivia question there. It does bring a lot in, and it brings a lot of notoriety, which we're in Kentucky, let's be real honest. Outside of Derby, we don't get a lot of attention, right?
KFC, what are you talking about?
That's not real fried chicken. But at the same time, part of me is glad that the industry has kind of flooded the market a little bit, and yet the demand has gone down, because those of us who actually really enjoy this, and I don't really care what the market's doing, I'm still going to be a bourbon guy. There's just so much more available at a more reasonable price, or it's just findable now. What used to be a unicorn,
Not
I
so
can
much.
find without a lot of work now.
Well, first of all, don't knock KFC. So I was just in France, bringing my daughter back home from her semester abroad. So she loved that. But outside of McDonald's, what was the number one fast food place
KFC.
I saw?
Absolutely.
I saw KFCs everywhere.
They're everywhere. Yeah.
So.
I don't want to knock it. I've eaten KFC many times. I am actually a fan. The famous bowl, with the instant mashed potatoes and the instant gravy and the corn. I like that. I admit.
Well, when you go overseas, the first thing they think about isn't the Derby. It's KFC.
That's right. It's KFC.
So.
But for those of you who are not from Kentucky, that is not the way Kentuckians eat fried chicken when we make it at home. So anyway, we've kind of beaten on the bourbon a little bit. I am a fan. I love this one. It's not something that I would go out and buy a lot of, but it's different, and I really, really like it.
It's different. It's definitely, like I said, a little light, airy. I enjoy it for sure.
I did put about 3 drops of water in it, and surprisingly enough, I noticed no change. It tasted and nosed exactly the same
I
after
didn't
I
notice
did
much
that,
of a difference.
which kind of surprised me a little bit. Okay, so we ready to get into phase 3?
Yeah, let's keep it. We're kind of already
try to keep
running up
this one
against time,
short.
so let's keep it short. But ultimately, level 3 is we're talking about Medicaid trust planning.
This is where we throw the word protection in. When a lot of people think about trust planning, they think about protecting the assets from something, be it the Medicaid spin down or be it protecting it from lawsuits and stuff like that. That's level 3 planning. A regular trust, the vast majority of them out there fall under that level 2 area. There is no protection. If somebody sues you, all of the assets in that trust theoretically are available to that lawsuit. In the case of a level 3, that requires what we call an irrevocable trust, meaning theoretically there are some ways. Once the money or the asset is in the trust owns it, the grantor who put it there cannot take it back out. It's no longer their possession because it doesn't flow through, if you will, the way that the revocable trust does. The reason that you use level 3, that protection part, is because you want to protect that asset against something, right? I know of one where it was not a Medicaid issue. That's by far the most common. But it was actually this was an elderly gentleman, and he admittedly was doing things he probably shouldn't do, like driving. Well, period. He shouldn't be driving anywhere from what I know of him. And I think you know who I'm talking about.
I do now, yes.
So the family actually did an irrevocable trust. He agreed to do it. All of the assets went into that irrevocable trust. So when he drives and he does something stupid and he causes an accident, and God forbid somebody is injured, the personal injury attorney can't go after any of his assets. They're not available in that lawsuit.
Yeah, so essentially when you're talking about level 3 trust planning, we're talking about creating an irrevocable trust, and what happens when you do that is you are essentially removing money, removing assets from your estate. Right. So you individually no longer own those assets. And at that point, the irrevocable trust, for all intents and purposes, becomes its own entity.
Yes,
it has its own tax ID number.
Yep.
You know, just like you have a social security number, the trust has a tax ID number. The trust itself pays taxes, right? And you're typically looking to protect yourself from a number of different things, but the biggest two things, well, really the biggest three things. Number one, Medicaid. In order to qualify for Medicaid, you have to be basically worth zero on paper.
You gotta be poor.
You have to be very, very, very poor. Not just poor. You have to be destitute, right, on paper. So you can't be worth anything on paper. So you basically have to remove all of the assets from your name and put it into an irrevocable trust. That's one. Estate tax avoidance. So we're talking about ultra wealthy clients here.
Yeah.
So this isn't something that the vast majority of people are going to have an issue with, but if you're looking to avoid some level of estate tax protection, this is a way to do it. You put money into an irrevocable trust. Once again, removing assets from your estate. Okay. And then number three, to your point, liability.
Yeah.
So you're protecting yourself from getting sued for whatever that may be. You hear about doctors a lot of times, truck drivers. Those types of professions where if there is some type of an accident that could occur, you're not going to be personally held liable necessarily, and you don't run as big of a risk of losing all of your money essentially. So those are the three big reasons why you would look to level 3 trust planning.
Now I'm gonna add a caveat to that, if you will. We typically don't talk about that level 3 with people until they're in their at least late 60s, usually mid to late 70s.
Barring certain exceptions.
There's always an exception to the rule, kind of a rule of thumb. So if you're listening to this and you're 40 years old, that is probably not in your best interest at this point in time. But one of the reasons why we do start having that discussion with our clients when they're in their late 60s, early 70s, primarily as a Medicaid issue, is there is a thing called a 5 years look back.
Yep.
Right? So we talked about you put assets into that irrevocable trust because they're no longer yours after 5 years. And that's the point. That money can be accessed for the purpose of Medicaid, for the purpose of lawsuits, to the liability story, things of that nature. Until it's been in there for 5 years, it still can be accessed under certain circumstances. So we typically have that conversation with clients in their late 60s, early 70s. We need to start talking about doing it at that age and probably executing it by mid to late 70s in most people's case, because 5 years from now, it's going to be much more important, and we got to get this ball rolling now. I will point something out because I've seen this happen with a client in the past. There are a lot of attorneys out there. Here in Kentucky, attorneys technically are not allowed to specialize. They all do. But technically, they can't say this is the only thing. I don't know how all that works. But when you are dealing with an irrevocable trust, I think any trust in general, but an irrevocable trust especially, please, please, please do not just go get your attorney friend of yours who finished law school a couple years ago. You need to get an estate attorney who specializes in this line of work. These are very complex. They are not cheap. Doing an irrevocable trust is going to cost you a chunk of money. It's worth it if it's appropriate.
A good attorney who does not specialize in it will tell you they don't specialize in it.
Yes, correct. I had one quick story. Somebody who does not specialize in estate law did an irrevocable trust for a client's parent in order to protect her from her own mistakes upon his death, right? It was written backwards. Just one of those unfortunate situations. The dad wanted it done to protect mom from herself in order to prevent her access, and it was worded in such a way that it actually granted her full access. It was a genuine backwards the way it was done. All of the assets, and I managed those. She wanted them. I had no choice. I consulted a couple of different attorneys. I had to do what I knew was the opposite of what he wanted, because legally I was obligated to do it. That money was gone in days. It was like, You know, the story of handing the 18-year-old an inheritance and they get a Ferrari and then a great weekend and that's it. So please, please, please make sure when you get this kind of stuff done, think about the end goal. Don't think about what you want them to do, right? Don't think about all the different types of trusts. I want to go get a Q-tip trust. Think about what you're trying to accomplish. Get an attorney who specializes in estate work. Coordinate them with your financial planner and let the attorney determine the type of work and the type of trusts or wills that need to be done in order to accomplish that goal.
Good deal.
And I think I'll wrap it up at that.
That's a good place to wrap up right there. Thanks for listening. Thanks for watching. Until next time.